Hi, everybody. I'm talking with Sharon Press. Sharon Press is a professor at Hamline University School of Law. She is the director of the Dispute Resolution Institute at the School of Law. And she has been in the negotiation and dispute resolution field for many, many years. For many years before joining Hamline, Sharon was the director of the Dispute Resolution Center for the Florida Supreme Court, which was in essence the arm of the Supreme Court which handled all of court-connected mediation and ADR throughout the state of Florida. And Sharon did that for many, many years, so many years, in fact, that I'm not going to say how many. I don't want to get in trouble. And I thought that is exactly why Sharon is the perfect person to kind of introduce students in this course to the topic of court-connected mediation as a context in which mediation is practiced.
Great. So court-connected mediation, in essence, is mediation just like mediation in any other context. The difference is that in the court context, you're talking about cases that people have already decided and, for the most part, filed in court. Mm-hmm. And so they have, at least one of them has sought out the court as a means for resolving their dispute. And in the sort of the early 80s, mid-80s, there was a move based primarily on the great successes that have been done in the community area of dispute resolution and also in family cases like dissolution of marriage, that this would be a helpful way to get people to move forward with their disputes. And the idea was that even though they had filed in court, that there might be an opportunity if the court suggested or if the court referred or if the court mandated the parties that they try mediation. This could be helpful both to the courts and to the parties themselves.
So it's a good moment to kind of catch disputes, or so the courts figured, a good moment to catch disputes right at this moment. So it's escalated, but it hasn't necessarily gotten to the peak of where it could go.
Right, and they certainly, I mean, the idea would be hopefully you get these cases out of the traditional litigation track early enough that the parties haven't gotten solidified in their positions and also haven't spent all of the money that they could spend if they were to litigate the case. And recognizing, as I'm sure everybody knows from their study of negotiation, that sometimes it's difficult when you are in dispute with someone to be the one to suggest, that it can be viewed as a sign of weakness, that maybe you're not as confident with your case. So that the idea was if the courts could intervene and be sort of the scapegoat of suggesting that someone get off the litigation track, that would be an easier way for people to do what in essence they were doing anyway. Because for anyone who's worked in a court context, you know that there's actually a remarkably small percentage of cases that actually are resolved in a trial. Civil cases, the resolution rate, and this is nationally in the U.S., the resolution rate is about 98 or 99%.
In other words, those are cases that resolve without going to trial, in essence, through some sort of negotiated and agreed upon way, one way or another.
Or it could also include dispositive motion. So, I mean, there's some amount of, like a summary judgment that the case just gets thrown out.
Right.
But the vast majority of things are resolved. The problem is that for the vast majority of them, they get resolved on what we call the courthouse steps.
Right.
So in other words, on the day of trial, after everyone has spent all of the money they're going to spend, and the court has already held the court space and brought in jurors if they're going to be jurors and all of that, and then they learn, oh, guess what? We resolved.
Right.
And the reason why it resolves on the courthouse staff is that that's the point of time that everyone has said, oh, okay, let me focus on the case that is now up and realize, I really should resolve this.
It's the ultimate moment of chicken, kind of.
Yes.
Yeah.
And so the idea behind a court-ordered or court referral is that you can get people moving that date back.
Yeah.
And so when this was suggested, there's all kinds of things that say, oh, that makes perfect sense. Now, the traditional mediation community was a bit concerned because one of the real foundations of mediation is that it's voluntary.
Right.
And traditionally that has been considered voluntary both on the front end, how do you get to mediation, and then voluntary as to what happens once you're in mediation. Well, so court connected, I like court connected better than court annexed, although some people use court annexed as a way to refer to it. And the reason I like court connected better is that over time, more and more of the court-related cases are not resolved actually in the courthouse. Private individuals mediate, and they mediate in a variety of places. So it's not really annexed to the court. But be that as it may, so we've got these court-connected cases, and the idea is that they are not going to be necessarily voluntary on the front end. And that was of concern to the mediation committee.
Now, how so? I mean, if a judge refers a case, so I imagine a judge can use different language for sending a case or referring a case to mediation. The judge can say, here's what mediation is, and this might be a good idea. And parties can do what they want. Or the judge can say, get the heck out of my courtroom and don't come back without an agreement. How does it work, or what have you seen? I bet you've seen everything. But
yeah. So, I mean, there's a real spectrum, as you can imagine, from the judge suggesting, this might be something you want to explore, and really no pressure at all. Like, for example, in conciliation court here in Ramsey County in Minnesota, the referees will say to the parties who have gathered on that day at the docket, at the start of the docket, he introduces all of the things, or she introduces all the things that are going to go on, and says, and by the way, if you are interested, there is someone available who, as a volunteer, is willing to assist you in having a conversation about your dispute and mediating for you. Right. Anyone who is interested, please just go to the back and the mediator will assist you. Anyone who's not interested, I will be starting to call the cases. No pressure at all. On the extreme other end are situations, and Florida had a very strong mandatory system where the judge could order the parties and say, you have filed your case in court, but I am not going to hear it until you first go to mediation. That obviously is not very voluntary, and they are required to do that. So I should pause here for a moment and just say that when we say court, it does also include really a gamut of cases. So from sort of the small claims conciliation court kinds of disputes, civil disputes, it includes family or dissolution of marriage cases. Yeah. It includes child protection, abuse and neglect of children, where the mediator is not mediating the abuse and neglect, but rather mediating between the parent or parents and the guardian ad litem and the state office that is concerned and charged with really making sure that a child is protected. Yeah. To the large civil cases, commercial cases, contract torts, personal injury, on up into the millions of dollars. So that's on the civil side. And then it also can include things like juvenile misdemeanor or other misdemeanors where there be victim offender mediation. All of those fall within this very broad context of court connected.
And in your experience, asking a very broad question about your experience, what has the outcome been? Let's start with one of the players. Has the court system been happy about the fact that it implemented a mediation system deeply within its system? Was that a good thing for it to do from a system-wide perspective? Looking at Florida, for example.
Yeah. So, it has been incredibly successful, both in terms of sort of outcomes as well as satisfaction.
Yeah.
And for me, the satisfaction of the parties had always been the paramount for me. Although, to answer your question directly, the courts have been quite pleased with how it has assisted them in managing their court dockets in ways that were much more helpful than if they had what had traditionally been going on, which is these cases were resolving, but not in a timely way and not in a way that was allowing them to really have any benefit.
Right. So while the court's interest in this, and this is what I've always seen as a major upside of the court-connected idea, is that while the court's focus is always, as it has always been, on managing the docket and clearing cases and lightening the load, etc., at some point in the line of who we put in place to conduct this or to manage this or something, at some point down the line, court administration will bring in or will rely on someone who does come from a mediation background. And that person will have court interests in mind, but will also have all of the generally benevolent, party-centered and party-benevolent and oriented intentions in mind that mediators tend to happen. And I'm guessing from the from the half smile on your face that that was kind of you.
It was a real concern of mine as some of my first pieces was around this notion of institutionalization of mediation and what does that mean?
Right.
And it actually reminds me that I really need to get back to this one point in terms of this voluntariness that I didn't finish that sort of close that loop.
Yeah.
So we talked about sort of this voluntariness on the front end and that court-ordered or court-connected mediation really has modified how we think about voluntariness. But what's critical in any kind of mediation, and especially in the court context, is that it has to remain voluntary for what happens in that mediation.
Absolutely voluntary, right.
If the parties are suggested, cajoled, encouraged, or ordered to mediation, that it has to be crystal clear that from the point that they begin that mediation, they are permitted and allowed to say, not working for me, I'm done, I'm out. Or at the point where they can't make an agreement, they have no agreement. It's not that the mediator then changes roles and all of a sudden says, okay, and so, after listening to all of you, here's what you need to do. That can't happen. Mm-hmm. So that it retains and really, and again, I'm very, very firm on this point.
I hear
that in order for there to be mediation, it implies and must include the fact that it is a voluntary process.
Right, and I hear this as something you're saying to counterbalance that sense of discomfort that many mediators have with the kind of creeping lack of voluntary on the front end, is as long as the bottom line is, if you don't like it here, if you're not happy with the process, you can walk. And it might be court connected, it might be court annexed mediation, it might be court ordered mediation, but it is still mediation and not court. And
right. Right, and that's a critical piece. And so that idea really does flow through all of it. And to come back to the question you had asked, is that in order to effectuate an appropriate mediation program in a court, I believe that it really is necessary that there be someone who comes not only from court administration, but who comes at it from the deep understanding of mediation and supervises and oversees and really implements and helps the court to implement these programs from that deep understanding of what the value of mediation is as mediation, with all of its voluntariness and self-determination is the word that I'm sure that the students have heard.
Yes, they have. And after having you serve in that role for so many years, it's easy to have a model now to point at and say, well, we need someone like that. Someone like Professor Press used to be down in Florida, and now it's all that much easier. Sharon, I first of all like to tell students that I will be dropping a link in right below this video to a paper of yours on court-connected mediation. And I just like to thank you. Thank you so much for sharing this with us.
My pleasure.